Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. The defense has filed a 22nd supplemental request for discovery. It was electronically filed on January 28th, and it is, again, the defendant's 22nd supplemental request for discovery, and a question has come up in the Idaho versus Kohberger case. Why is the defense asking for the same things over and over again? Is it that the state of Idaho is just refusing to participate in good faith discovery? No, this is not why one files supplemental requests for discovery. If there is a discovery request and the other side responds and refuses to turn over the requested discovery that the initiating party feels is relevant and may be necessary for the defense of their case, the appropriate thing to do would be to try to work out this disagreement in good faith amongst the parties. Sometimes, very frequently, that gets things resolved. Other times, however, no matter how much on both sides people try to, in good faith, resolve discovery requests and disputes that come over discovery requests, they simply cannot. They both feel that they're right. One side feels that the information's discoverable. The other one feels that it's protected or irrelevant or harassing. And then what you do is you file a motion to compel discovery. You don't go back and ask for it 10 or 20 times. What happens with these supplemental requests for discovery is you might serve a discovery request. And then depending on the response that you get, you may say, oh, wow, this opens up a door to an area that I need to file a supplemental request for. Let's give an example. Say this is a civil case and you were to represent a supermarket where someone has come in, has slipped and fallen and broken their arm, and now he or she is suing the supermarket for negligence to get back money for pain and suffering, to pay the doctors and the orthopedic bills for rehab and so forth. And you serve discovery asking about any pre-existing situations, and they come back and they admit that, yeah, there has been a prior issue with that arm. Well, then you might serve a supplemental request for discovery asking for a little bit more clarifying information. Who treated you? Which doctors? When did it happen? What was this all about? So what we see here is Mr. Kohberger, in this 22nd supplemental request for discovery, stating as follows: please take notice that the undersigned, pursuant to Rule 16 of the Idaho Rules, the 4th, the 5th, the 6th, the 8th, and the 14th Amendment to the Constitution of the United States, and Article 1, Section I-2, 13, and 17 of the Constitution of the State of Idaho. This is the legal authority that allows him to ask for this discovery. And it goes on to the next page and says, requests discovery and inspection of all materials discoverable by defendant per, and then the rules given again, and the aforementioned constitutional provisions, including but not limited to the following information, evidence, and materials outlined in Exhibit U. And as we have seen since the beginning of the case, both sides, what they do is when they file on the part of the defense or the state a request for discovery, they do so in an item under seal, typically an exhibit. Exhibit U tells you and tells me that there have been exhibits A, B, C, D, all the way down through the alphabet, and the next letter is U. That's where the discovery request is, in that Exhibit U, sealed from the public. This is dated the 28th day of January 2025, signed by Ann C. Taylor, lead counsel for Mr. Kohberger. If you would like to review this document, and I always encourage you to read the docket, read the filings, and come to your own conclusions regarding this case, please go to the link that I have provided in the description to this episode of the Indie Zone podcast. And as always, I want to thank you so much for your time and your attention today.